counsel, these proceedings are being video and audio recorded, so I'd ask you to please identify yourselves and your clients at the beginning of your respective arguments. And because this is an accelerated appeal, we've allocated 30 minutes per side for arguments. Don't feel obligated necessarily to fill those 30 minutes, but take what time you need to fully present your arguments. Appellant, as counsel, you're responsible for watching the clock and reserving whatever portion of time you desire for rebuttal. And also, please keep in mind, or I'm sure you're already aware, that we've read the briefs, obviously, and conferenced the case and are familiar then with the general facts and issues in the case. With that, counsel for appellant, you may proceed.
Good morning, Your Honors. My name is Paul Eckstein. I'm appearing on behalf of the appellants. With me at counsel table is my partner, Jessica Everett Garcia. As you know, at issue today is whether a law that applies only to one of Arizona's 10 community college districts violates any of the three prongs of the Arizona Supreme Court's 1991 decision in Republic Investment, thereby creating a special law or resulting in a special law that violates the Arizona Constitution.
Counsel,
Now,
if
yes,
Maricopa County has the only extremely large community college district, how is it irrational? I mean, I'm not saying that there are issues with other elements of the test, but how is that irrational?
well, I would like, Your Honor, and I'll answer that briefly and then come back to it. But it violates all three of the prongs: the elasticity prong, the inclusiveness prong, and the rationality prong. I plan to start with and spend most of our time, as I did in our brief, on the elasticity and the inclusiveness prong. But you've focused on the rationality prong. And it's irrational for the reasons we stated in our brief. Number one, the reasons that were given by the state, not by the legislature when they adopted this, because as you know from looking at Exhibit 9, there's no explanation that Maricopa County is in need of more representatives. It's absolutely silent as to that. The only thing the House of Representatives report says is that Maricopa County has a population of X, which was over 3 million, and Pima County has a population of Y, which was under 1 million. No legislative history like in the city of Tucson versus Woods, which says when you're looking at rationality, you should look at what the reasons were for that. So the assumption is that because it's larger, it's entitled to more representatives. There is a disconnect there, and the disconnect is really pointed out in the appellee's brief when they say, well, there are more students, more money, more other things that are more directly related to a need. I submit not related enough to say there should be a difference. But if you're trying to connect a need with population, I think it's hit or miss. It is not rational. But I want to, that's my answer for now. I would like, with your permission, to talk about elasticity. The leading case, as we all recognize, is Republic Investments. And Republic Investments was decided by the Arizona Supreme Court in 1991. It set out a three-part test that, as I said, in order to be a general law, a statute must be rational, it must be in a class that is inclusive, and must be elastic. Elasticity means that parties can come in and out in a reasonable time, in a reasonable fashion. The state says, no, reasonable time is not something that the courts have decided. Well, the courts have decided that, starting with the Republic investment case. Republican.
Counsel, in that case, though, that was by definition a closed case because the class was determined by the population at a particular census, on a particular census day. So that, by definition, is closed.
It was clearly that was a closed class.
So how does that affect a case such as here, which is at least facially open?
Well, the court sided with approval and actually approved the decision of this division, saying that in order to be elastic, the people coming in and out had to do so within a reasonable time.
But
it is clear.
Well, but that case was also a closed class.
That was a closed class, there's no doubt. And the city of Tucson v. Woods was a closed class. But the language that is set forth by the Supreme Court in Republic Investment was relied on by three decisions in the Court of Appeals. One in Division 2 in Ray Cesar, one in the Marxist case, and the other more recently in Town of Gilbert. In each of those cases, they cite the language that we cite about a reasonable time, and indeed what at issue in those cases were open classes. There's no dispute about that. The state says, well, they're not relevant. They are. They're the absolutely most relevant decisions we have, and the only decisions we have on a temporal provision.
Because how do you square Town of Gilbert and Cesar with Long?
Easily. Long doesn't purport to look at when another county might have a football team or might have a population of 2 million. The temporal issue was not decided in Long. It clearly is not. There's not a word in there that says that 10 years, 20 years, 30 years for another county to have a population of 2 million is too long or too short. That was not decided by the court in Long, and even if it was, the Town of Gilbert case is subsequent to the Long case.
Counsel, what if the court in the Long case, or in the trial court, I don't know if it was or not, but what if the information such as what your clients have presented here, the type of expert disclosure affidavit, what if that information had been presented in the Long case? What would be your answer to the case? Would the outcome be different in Long?
Oh, I think so. And as you know from the opinion, we were involved at the appellate stage. We were not involved at the trial stage, but it was not presented. And yes, that makes all the difference in the world. At least it should have made all the difference in the outcome. I will say that there is a significant difference that we point out in our briefs between Long, which involved one NFL team that was in existence and likely to be the only one in existence, and our situation here where we have 10 community college districts that were established by the legislature that are in existence and have been in existence. We didn't go back before 2010, but you have those community college districts that each of which has similar problems to the problems in Maricopa County. Now, if there's a difference, it's merely a difference of degree and not of kind.
under the analysis that you put forth today and that you put forth in your brief, is long wrong then? Is the outcome in the long wrong?
Well, I have a lot of emotion involved in in the Long case, and I think we understood that when we took that for a court to say, for all practical purposes, there's not going to be an NFL football team in Arizona, was a long shot, and that long. We did say it was sui generis, and I still say that is sui generis. I think it is clearly distinguishable from our case, and I understand the analysis. I read it when it came out, and I've read it a number of times since. Look, this court in town of Gilbert in 2006 had the Long case before it. It referred to it. It referred to a Republic investment case. It referred to N. Ray Caesar and Marcus. It had all that before it. If Long is controlling here, it should have been controlling in the Gilbert case. Marcus and Caesar were before Long, so it couldn't have controlled those decisions. But what's key is I keep coming back to on elasticity, the fact that you have a number of districts that would benefit from, quote, better management, closer management, closer control, and they are not going to be able to participate in that maybe forever. The expert said, if ever, and he said the most probable time would be in the 22nd century.
Well, because that seems to be more a question of whether the six-story classification, which is all similarly situated, remember, it's not elasticity.
Well, when you read, and I'm sure you read Republic several times, as I did in the last several days, the discussion on elasticity and inclusiveness does go back and forth, and it's not easy to separate that discussion. I acknowledge that. I want to make this. Yes, Your Honor.
Let's assume that we accept that Republic investment does require a temporal elasticity requirement. Technically, it never uses the word time, but it does refer to that it's more probable than theoretical that an entity could join the class or exit from the class. And I think it uses not only possible but reasonably probable of attainment. How do we draw the line? What factors do we look at as a court? And I was looking at. They don't have paragraphs, but it was the next to last paragraph of Part C of the Republic investment that refers to that. So let's assume that we agree that there is a temporal requirement. How is a court? What guidance should we be giving the legislature as to what factors to use? I mean, one, is it a bright line test? Is it better be reasonably attained and within 10 years, or it's not? It's inelastic, or are there factors we should use that a court and a legislature could consider, and whether it's elastic or not? And what are those factors? Or is it like pornography? We know it when we see it, and we're just going to have to take each case on its basis to see if this is elastic.
Reluctant to say that it's like pornography.
I'm not sure I could say that.
For fear of admitting that I've ever watched pornography. First of all, I disagree, Your Honor. The court does use the term time. It quotes approvingly from the Division I decision at point 9, where it says, and thus, within operation of the law, within a reasonable time, or if at all. And then at the end of the opinion, as I noted at the outset, it says this, the opinion of the Court of Appeals, Division 1 in petitioners is approved. Is approved. That is where that language comes from.
And there is in the conclusion it says it's limited application both geographically and in length of time. So you're right. Okay, but let's assume that's not obiter dictum. And
Well, the court-
I don't think it's. I don't mean to say that I think it's obiter. I mean, I'm assuming for purposes of this discussion that temporal requirement exists.
Not only
How do we determine it? Where do we draw the line?
Your Honor, it not only exists, it's binding on this court. It's binding by virtue of Republic investments, and 3 Court of Appeals, separate Court of Appeals,
Counsel,
have decided that.
I'm not trying. I just don't want you to divert you and to think that, oh well, gee, I'm thinking that it's obiter dictum. I don't think it is. I want to know how do we determine what is a reasonable or probable length of time?
Okay. First of all, the 3 courts that decided the temporal issue, they had different periods of time. We, in this case, are at the extreme. Using the facts most favorable is the most aggressive growth of Pinal and Pima County. You don't have Pinal County, which arguably for other reasons may not ever get to it, not getting it to it until 2090, 80 years after the legislation was passed. And Professor Rex says, more likely, if it happens in the 22nd century. So I suggest to Your Honor, excuse me?
Why is that too far for a legislature to look forward?
Well, if that's not too far, then the legislature can put in for any test in any time period right below or right at the population figure for whatever city or town or school district or county that's involved, and that it becomes an issue of not probability but technical possibility.
Is 50 years too far out?
Excuse me?
Is 50 years too far out?
Well,
How about 45?
yes, 50 years is too far out. That we're dealing with a minimum of 80 years and maybe 150 years here. But let me suggest, I want to get to Judge Kessler's, how can you come up with some kind of reasonable standard? Well, let me suggest that one way to look at this and determine whether it's too far is to take the actuarial lifespan of those who are in the legislature at the time it passes, and to see whether a single legislator using the actuarial tables is going to be around when the event is going to occur. And here, you start with you have to be 25 years old to be in the legislature. 85 is the actuarial time. This exceeds that. If Judge Rex,
rule against perpetuities.
Well, I was going to suggest, Your Honor, this approach. We all know what the rule against perpetuities is. That 21 years. Well, we struggled with it.
But does the legislature understand?
We struggled with it. I struggled with it. But 21 years after all lives in being, if in fact this doesn't happen until sometime in the 22nd century, it would violate the rule against perpetuities. Those are 2 pretty good tests if you're looking at time. But we're so far beyond what was involved in Ray Caesar and in Marxist and in Gilbert, where you're talking about 10, 15, and 20-year time periods. Here we're talking at a minimum of 90 years from 2010 when the legislation was adopted.
So putting aside the rule against perpetuities, to my understanding, your argument is essentially, I'm not sure how you judge what is reasonably probable to meet the test, but certainly 90 years to 500 years, if at all, is not a reasonable probability. Is that a fair summation of what you're
Yes, that's exactly.
Okay.
That's exactly what I'm saying.
No,
Yes,
so
sir.
if you were to advise the legislature on how they could have or should have drafted this to address this problem, this concern, this challenge that they're having in Maricopa County College District, not necessarily Maricopa County, but in the community college district, how could it have been structured differently?
Two ways, Your Honor, and we pointed out in a footnote in our brief. One is to lower the population threshold. That's an obvious way. Article 6, Section 40 of the Arizona Constitution, which deals with the judiciary and provides for merit selection, provides that merit selection for Superior Court judges is for counties in excess of 250,000. But it also says in Section 40 that if there's another county that wants to have merit selection, it can opt in. The opt-in provision is there with respect to this. The legislature could have done that, and of course it can do that going forward with respect to this legislation and other legislation that may be at issue. I want to make clear that each of these temporal provisions has got to be looked at individually, and a rule in this case finding this particular statute, which applies to one county where you have other counties that have similar situations in that they have community college districts, is different than any of the other statutes that are cited. With that, I'd like to reserve my yes.
I'd ask you to opine on just one or two more things. Do you have any idea or a guess as to why the legislature drafted the statute in terms of the population of the county as opposed to the district? It's the language of the. Why would it matter what the size of the county is? Doesn't it matter what the size of the district is?
Well, that was the point that we raised. Absolutely, Your Honor. The trial court Judge Warner asked us, what was behind all this? Well, the papers, the popular press, explained what was behind it, but we didn't try to get it into evidence, and we didn't try to get legislators' comments on it because it's not admissible. But the fact that you see only Maricopa County with its population and Pima County with its is a good indication that the legislature did not think seriously about the population. I mean, there is no evidence, as the court suggested in City of Tucson versus Woods, that there was a reasonable basis for doing this, other than saying, well, Maricopa County is the biggest, and therefore it's entitled to it. There's no doubt, I think, maybe counsel will differ with me, that if instead of saying a county with 3 million, the legislature had said Maricopa County, that this would be a special law. Now, it would be special because, as Judge Howe has pointed out, I mean, there you have a closed class. No one has any theoretical possibility of joining, but that's not the test.
If you split the county.
But
what if there's a county split, Maricopa County?
And then, then you've got a whole new problem.
Is that theoretical?
But getting back to your the option in response to Judge Brown's question. So if I understand it, the legislature could have said, okay, population of 3 million or more, and smaller counties can vote to opt in to this to have two additional members.
Correct.
And that would solve the elasticity problem.
I think it does. To me, and I think it. I view the elasticity and the inclusiveness prongs as very similar. I want to say a word and get to it. And I'm using up my rebuttal time on rationality. I got to say, I mean, you're stuck with the test that every piece of legislation, in order to be effective, has got to be rational. I don't think that really adds anything, the rationality test. If it's not, there's not a rational relationship between the statute and what it seeks to do, it's unconstitutional under substantive due process. So the focus has got to be on inclusiveness and on elasticity. One final word. In the town of Gilbert case, you will see that this court found that statute to be rational, rationally related with respect to the need for fire districts, but went on to find that the inclusiveness prong and the elasticity prong had been violated. So with that, I will save the rest of my time. Thank you.
Good morning, and may it please the Court. Robert Ellman for the State of Arizona. Your Honors, the Arizona Constitution does not tolerate laws that bestow special benefits upon favored localities. The test the Court has been discussing this morning enforces that principle without paralyzing the legislature and precluding it from acting rationally. There is nothing in the three-part analytical framework designed in the Republic case that requires legislators to disregard critical distinctions between localities for the sake of arbitrarily causing a class to expand or contract by an artificial deadline that has nothing to do with the purpose of the legislation. If you look at the way that this Court has repeatedly addressed elasticity, it's this way. A statute is elastic if it is actually probable that the class will expand or contract eventually, so that the class is not permanently confined to its original members. And that is not descriptive language of my choosing. That is within the holdings of those cases themselves. And I cite you to paragraph 21 of Town of Gilbert, where it says eventually, and that's the holding of the case. And I cite you to paragraph 38 of Long v. Napolitano. Long v. Napolitano does not specifically address the temporal limitation element of elasticity because there is no such element. Opposing counsel told you that the critical language in Republic Investment Fund is within a reasonable time, and that is the language that this Court relied upon 3 times in re Cesar R., in re Marcus B., and Town of Gilbert. If you look at those decisions, the words within a reasonable time do not appear in any of them. The words within a reasonable time were quoted from petitioners for de-annexation in the Republic case.
Counsel, in Republic Investment, in the conclusion, the Court says, even if the statute is deemed rationally related to a legitimate legislative objective, its limited application, both geographically and in length of time, means that the statute is a special local law. Okay. I mean, that uses the word time, length of time.
It does, Your Honor.
And when you read that in light of that it must be not only possible but reasonably probable of attainment, which the Court talks about twice, that seems to me that there's a temporal element. Despite the fact that I grant you that the Republic Investment was a closed class, they didn't have to use that language of possibly reasonable of attainment and length of time. They didn't have, the Supreme Court didn't have to use the language. They did, and we have been guided by that. So I don't know how you get around that.
Your Honor, if the Court wants to breathe life into the phrase within a reasonable time, and it's certainly rational to do so based on the passages you've just quoted, it's for this purpose. If a class is tied to a census date, it's a closed class. But it's also a closed class if it's tied to a window of time that is artificially narrow. For example, in this case, if the statute had been written to say that it applies to any county with a population of 3 million or more by the year 2025, then I would agree with opposing counsel that it would be unconstitutional. And that's what.
But what happens? I understand that. That's a fair statement. But what happens, to me at least, it's a fair statement. What happens if you have evidence that seems to say, you know, it might be by the bicentennial of our state's founding that maybe there's a 20%, I don't know if that's the evidence, but 20% chance of another county attaining this, if ever. Is that because it's not tied to something that clearly there's no, it's infinitesimal chance of anyone ever entering? Like they have to reach 3 million by 2020. You're saying short of that, if it were 1,000 years, another millennium before a county reached that, that would be enough?
Well,
that would be reasonably probable?
Well,
reasonably probable?
I think you may be blending two different concepts here, Your Honor. There's possibility and there's actual probability. And this court, in describing actual probability, says permanently and eventually. And that does imply.
But the Supreme Court used the word reasonably probable of attainment. So if someone says 500 years,
Your Honor,
or if ever, under the best of circumstances, that would be good enough?
it says reasonably probable of attainment. It doesn't say reasonably probable of attainment in the near future.
Right, but it does talk about time. I mean, by that theory, I mean, let's just take that to its logical conclusion. Someone brings in an expert that says, in the next 10,000 years, Pinal County may reach 3 million. That's good enough. Is that what your argument is?
Well, Your Honor, I think if you press a time boundary out that far, it becomes meaningless, and it's effectively, it is never, because I don't think you could ever build a doctrine on a point like that.
Fine.
You don't have to draw the line under this court's case law, Your Honor. There is no temporal limitation incorporated in Republic. And I'd like to explain, because I think that becomes clear when you look at the rest of the Republic case. First of all, it says within a reasonable time, or if at all. Now, under the appellant's construction, the words or if at all wouldn't have any meaning if the temporal limitation is what they say it is. That's at page 149, Your Honor. And again, that's being quoted from the Petitioners for De-Annexation case. And if you look at the following paragraph where the court actually articulates the applicable test, it doesn't use the words within a reasonable time. Third, the elasticity discussion itself in Republic spans 2 pages. It's at pages 150 and 151. There's no reference anywhere in that discussion of within a reasonable time or a temporal limitation. And the other phrasing...
But I just went through... I mean, I understand where you're going with this, but I just went through that on page 150, they talk about possible but reasonably probable of attainment. And then in the conclusion, they say both geographically and in length of time. And so, and I guess what I'm getting confused about here is at one point we're saying, if I understand what you're saying, and it may be that I'm just not clear about it, is on one hand you're saying, well, there is a temporal limit, but it's got to be so far either impossible to attain or so far in the future, 10,000 years, that it's just not reasonably possible. But on the other hand, I think I hear you saying, but there really is no temporal element.
There is no temporal limitation, Your Honor. There has to be evidence put into the record by the plaintiff challenging the statute that it is actually improbable. And I'm sure the court is aware of this, but it's the plaintiff's burden to demonstrate beyond a reasonable doubt that it's improbable that another county will...
But you're saying it doesn't matter, right? You're saying it doesn't matter as long as there is no temporal requirement.
No, it does matter, Your Honor, because they have to demonstrate that it is actually probable, not merely possible. And that's the distinction that I think is being blurred here. Their own evidence demonstrates that it is actually probable that Pinal County will have not just 3 but 3.5 million people.
But you're saying but you're saying that there is no temporal element to that. Is that? In other words, if it's 500 years, it's okay.
I am, Your Honor, because I'm relying on this court's phrasing in Long and Town of Gilbert, where it makes clear that there's no temporal limitation.
So, counsel, as long as the definition of the class is facially open, then it's Katie bar the door in terms of time, then?
No, Your Honor. If it's facially open, it still may not be possible for another class to actually enter it. I mean, it may be impossible by virtue of facts or circumstances, only if it's probable. So that's the facial component of this. All right.
Well, to take the earlier example, then, saying the evidence was that Greeley County will hit 3 million several thousand years in the future, that's reasonably probable because it will happen. It will just happen when we're too old to care about.
I think that's the same. I think that's the same question that Judge Kessler was asking me, and I don't think I've been avoiding it. I think the answer is no, but I also think that there will never be a case where testimony is or evidence is to that effect, and it's difficult to believe that the legislature would concern itself with something of that nature. The test...
Counsel, let me flip the hypo there. Let's talk about Greeley County. Population of, 8,000 people? Let's say that they have severe economic development issues, which they do. So, and if the legislature wants to help a rural county, and especially a small county, and whether they mean to hit 1 or more or not, but let's say they set a 10,000 population threshold, that no sales tax will be paid by any business that's located within a county less than 10,000. And so from time forward, from this time forward, in order to promote economic development, how do you go about evaluating that to see if it's a special law under elasticity?
That is patently a special law because there's no relation between the population-based classification and the problem that the legislature is trying to address, which is an economic situation. That has nothing to do with population, and that's the same situation.
But if they're the smallest county, the only county that really needs the help. How can the legislature help them?
The legislature can help them by designing a statute that turns on economic conditions, not the population of the locality. Okay. And that's exactly the situation.
So weren't there ways through that the legislature could have done the same thing here? That could have turned on different conditions other than population?
It could have, Your Honor. The question about the size of the district as opposed to the size of the county would be one example. But the test isn't whether there is a better or more rational way. It is only whether the legislature's decision itself is rational. In Re Cesar R. and in Town of Gilbert, the problems addressed by the legislature had nothing to do with population, and that's why they were struck. A juvenile carrying a handgun really is a problem that doesn't turn on the size of the county. That's the first reason that the court rejected it.
So let's change the hypothetical a little bit. Let's say the legislature says that Greeley County has 65% of its, let's say 65% unemployment rate, theoretically. Mm-hmm. Says we want to do something to economically help any county that has a 65% unemployment rate, and so they pass a statute that does that.
So far, so good, Your Honor.
So far, yeah. No other county is even close to 65% unemployment rate, and there's no evidence that any other county, barring a major disaster, would ever reach that. Is that inelastic? Can only a county? There's no evidence that maybe, barring a major depression, that any other county in our state's going to ever hit 65% unemployment. Is it a special law?
That's the difficulty with the plaintiff's theory in this case, Your Honor. You're describing a circumstance that the legislature should be compelled to correct in exactly that manner. As long as it doesn't say Greenlee County and the other county in your example,
They're doing
then it
by
has
in-
to be
but
valid.
it's in doing by indirection what they can't do directly. They can't say Greenlee County, but they can peg a figure so that it only applies to Greenlee County.
Well,
And there you're saying you can't do it facially. You can't say Greenlee County, but you can certainly say 65% unemployment. And maybe, there are other counties that have 50% unemployment or 45% unemployment, but they're not going to hit there's no evidence they're going to hit 65%.
I think
You're saying that's still okay.
I think I can demonstrate it with my own example, if I may, Your Honor.
Sure.
I mean, I think we all acknowledge that with urban growth in densely populated areas, you typically develop problems with congestion and air pollution. And I think it's also fair to say that in Arizona, as we stand here today, there are two metropolitan areas that suffer from that problem: the Tucson Statistical Metropolitan Area and the Phoenix. Now, the legislature could very rationally decide to address that problem statewide by putting a subway system, a very expensive proposition, in any metropolitan statistical area with 1 million or more people. Now, that would include both Tucson and Phoenix. And we might all agree that the problem became acute in Tucson when they hit 700,000 people. So the legislature would rationally choose any county of 700,000 to keep it from being facially special legislation. Now, under the plaintiff's interpretation, that statute is perfectly reasonable and perfectly unconstitutional because the third largest metropolitan statistical area in Arizona is Prescott. And Prescott is not going to approach 700,000 people for many, many decades. So the legislature now has two extremely undesirable alternatives. It can ignore the problem to avoid creating special legislation, or, and I'm going to borrow opposing counsel's example, the obvious way to fix this, he said, is to lower the population threshold. So let's say that they do that. Okay, they find the mark where Prescott is going to be in 20 years, and to keep the legislation from becoming special, they peg it, instead of at 700,000 where it belongs, at 250,000, so that it's actually probable that Prescott will reach that. Well, now you have corrupted the inclusiveness factor because Prescott is not similarly situated to Phoenix or Tucson for purposes of this problem. Moreover, once they reach it, the class is closed again for longer than what is acceptable to the plaintiffs because
Why couldn't you do the opt-in provision?
the opt-in provision still renders the legislation special. If the legislature were to say that Maricopa County alone would have the benefits of a subway system and other counties could opt in, you're still treating Maricopa differently. It's still facially special legislation.
All counties could opt in. I mean, if Maricopa County needs a transportation system, why can't the legislature say, voters of Maricopa County, if you want a transportation system, vote one in. Here's the mechanism.
Well, the legislature can do that rationally, Your Honor, but I don't think it's rational for the legislature to conclude that any municipality that wants a subway system should be able to opt in. It defeats the rational prong of the three-part test. It applies to this very case,
I mean, there's
Your
lots of
Honor.
hypotheticals and directions this could go. I mean, I guess, what is the future of, what is the purpose behind the special law clause of the Arizona Constitution? If it has any meaning to going forward, if we're to uphold this law, then what does that mean? It seems like your position is 1,000 years would probably be fine. A couple thousand, I don't know, maybe 10,000 is too much. It still seems like we're engaging, I don't know, beyond the actual probability. I don't know how far out in the infinity, close to infinity that becomes. But, as the day comes, and we may already be there, where Maricopa County controls the legislature by the number of seats it has, isn't that an interesting dynamic, to say the least, that they control what happens in this county? Going forward? What is the goal behind the special legislation clause?
The goal is to preclude the legislature from bestowing special benefits upon a favored locality. And that's what the plaintiffs have to demonstrate occurred here.
So I know you
And they haven't
mentioned
done
the evils that are going to come with a large county and with transportation things. What about water? What if the legislature says Maricopa County has by far most of the population in Arizona? Therefore it needs the same percentage of water. And we'll begin by taking water from the White Mountains, from Yavapai. We will do that because that's what's necessary and prudent for Maricopa County. Would that be a special law?
It would be the way that you're describing it, Your Honor, and it's also irrational if people in Maricopa County and people in other counties have the same need for water, and you're
Well,
taking...
Maricopa County has a greater need because they have more people.
Well, that can't be addressed in the manner that you're describing because it specifically targets Maricopa County
Well, if you had a
for a
population,
benefit.
if you said any county that is over 4 million people would need to have a special water authority set up that would allow you to take water from different counties.
With the idea that Pima or Pinell County would reach that in, let's say, 500 years.
If the need for water arises from population growth itself, then it's at least theoretically possible to design a population-based classification where actual probability is satisfied. But that seems rather authoritarian in the manner that Judge Brown is describing it. You can certainly examine the facts and circumstances and have your suspicions aroused if you have a statute like the one in Town of Gilbert, where you have this very peculiar set of population parameters that don't seem to be tied rationally to the underlying purposes of the statute.
And of course, we're still struggling with this seems to be many a gray area, to say the least, of how one determines, or, in fairness to the legislature, how do they look at a statute and determine that this population threshold is going to be sufficient and this one is not? 10 years out, 20 years out.
Well, I think the converse creates the problem, Your Honor. If you're requiring the legislature to pore over statistical tables and population
Wait, no,
charts.
I'm saying, the law's on the books right now. We're not changing anything. We have case law that says 10 years is too long and 19 years is too long. It does exist.
I disagree, Your Honor. I do not believe that is the holding of In Re Cesar R, and it's certainly not the holding in Town of Gilbert.
Well, Counsel, my reading of Town of Gilbert and Cesar is that they do invalidate the statutes based on other elements of this special law analysis, but they very clearly also address elasticity in the population threshold. And in Town of Gilbert, the court held that the town of Buckeye would satisfy the geographic and the population triggers for the statute in 19 years at that point, and 19 years was too long, and in Re Cesar it was 10. So I understand your argument and your reading of the cases that Town of Gilbert and Cesar invalidated the statutes on other grounds, but they very clearly rely on elasticity to invalidate it as well. And how do we deal with that? And to follow up on that, it seems inconsistent to me with how long it came out.
Well, if Cesar R and Town of Gilbert actually hold that there's a temporal limitation, then they are in direct conflict with Long v. Napolitano. And then you have to choose between two reasonable interpretations, only one of which will render the statute constitutional. So problem solved there. But I don't agree with one aspect of the way that you're reading Cesar R and Town of Gilbert. In Re Cesar R, all of the critical analysis occurs in paragraphs 8 through 11. In paragraph 8, and we're talking about a Division II case here, the court states the standard from the Republic and does not mention anything about a temporal limitation, including the within a reasonable time language. In paragraph 10, the court mentions the 10-year time limit that you've spoken of, and says that the next county, I believe it was Mojave, would be eligible in something like 10 years, or Buckeye. I can't remember, the cases are blurring a little bit. But that's not where the holding is. The holding is in paragraph 11, and in paragraph 11, Division 2 says nothing at all about temporal limitation. It says that the statute's inelastic because it limits its application to Pima and Maricopa counties. It makes improbable entry and exit by the other counties. It doesn't say entry and exit within a reasonable time, much less within 10 years. And in paragraph 9, I just want to point out, the court says even if we assume that Mojave's growth is constant, there's no finding there, Your Honor, and it's really putting a lot of pressure on a statement in a case to attach an entire doctrine to something that's not even a finding. And the same thing.
Oh, I'm sorry. Go ahead.
The same thing is true with Town of Gilbert. There's no near future analysis in that case. There are. Yes, Your Honor.
What about paragraph 23 of Town of Gilbert? I mean, the court says the trial court heard evidence that the town of Buckeye could theoretically join a district with the requisite population, but such a possibility would not occur until 2025. The remote possibility of only one other entity being able to enter the class in the next 19 years is insufficient to satisfy the third prong of elasticity.
Yes, Your Honor.
What does that mean? So you're saying that doesn't have a temporal requirement?
Your Honor, it says remote possibility. It doesn't say actually probable. And the question assumes that both of those things are the same.
We have to have an expert say there is a more than a 50% chance within so many years of within 10 years or 15 years before we have probability?
No, Your Honor, because you're reincorporating the temporal limitation. The testimony has to say it's actually probable, but it doesn't have to say when.
Then why did they use the 19 years? Why didn't this court just say the remote possibility of one other entity being able to enter the class is insufficient?
The court could certainly have done that, and it would have been truer to the holding in Republic if it had. That the fact is, the evidence in that case showed that the 19-year mark was what the testimony led the court to. The language in the case tracks the testimony itself. It doesn't mean that there's a 19-year temporal limitation within the case. And again, in Town of Gilbert, Your Honor, it's the same phenomenon. The plaintiffs have to demonstrate that it's actually improbable that the class is going to expand. And of course the evidence goes to whether that will occur or not. So of course it's going to discuss when these towns will reach that population limit. And there were two contingencies with Town of Buckeye, Your Honor. One of them was population, but the other was whether they would join a fire district of the requisite size. There were actually two criteria there. And it would not meet the second criterion in that case. So that's why that case wouldn't work.
So if an expert came in and said there's a reasonable possibility.
Possibility or probability?
A reasonable probability that Greenlee County will hit 3 million people.
That satisfies the standard, Your Honor.
And it doesn't have to have, it could be 10, that doesn't have to say, and if that expert's question and saying, well, when, the objection would be there's no temporal requirement. It could be in the next millennium.
That's correct, because
and that
that's
would be sufficient to match it.
Yes, Your Honor, because that's what this court says in two different cases, in two different holdings.
So
and
if legislature wants to design a special law, but wants to comply with a special law analysis, all it has to do is select a population threshold that will be met, but it may not be met in anyone's multiple lifetimes. Then that would satisfy the special law analysis.
Well, you're only concentrating on one part of the analysis, Your Honor. It still has to be rational, and that is That's the effective part of the prohibition in what you're describing now.
I have to admit, counsel, the rule against perpetuities is starting to sound a lot better to me right now.
Well, I understood that rule for about 3 minutes, about 20 years
More
ago.
than I do. But I mean, I am troubled by the fact that if an expert came in and said it's reasonably probable that sometime, anytime, Greenlee County may hit 3 million people, and therefore the class is elastic, does sound a little bit, I mean, almost more than theoretical to me.
Well,
I mean, unless there's some time limit. I mean, some time limit, because you could peg it in 10,000 years. And
Well,
it would be in the end, if the expert would say, I don't have to give you my time limit because there's no temporal requirement. So I am
but it invites
troubled.
it does invite the problem, Your Honor. If the legislature wants to resolve a snowfall problem, and the only county that has a snowfall problem is Coconino, what's the legislature supposed to do unless it wants to send snowplows to Yuma at some point in the future?
But
I mean, that's the vice of this temporal
Up
limitation.
in the provision and see if Yuma wants to
Well,
pay for the snowplows.
As I said, it would still be special, but I mean, I can specifically demonstrate the problem in this case, because if they had lowered the population threshold to 980,000, they would have brought Pima in, and it would still be inelastic.
But if you do have an opt-in provision, assuming they say, okay, this is a problem, we see a problem that shall at 3 million, and it may at lower levels if the local jurisdiction thinks it needs more directors. I mean, it seems to me that could support both the rationality and the elasticity and the inclusion. But
Well, that, again, on its face is still special legislation, Your Honor. It does treat Maricopa County differently if it does that.
it allows other people to opt in.
Well,
With the may.
I think what this comes down, if I may conclude, Your Honor, I see I'm out of time. I think what this comes down to is simply that one size does not fit all, and that the legislature should be free to address problems where and when they arise without resorting to predictions of when other members will come in or fall out of a class. Thank you.
That's a thank you.
Your Honors, I will follow the admonition of the court and not use all of my time and make myself available to questions, but I have no points that I absolutely have to raise on rebuttal.
No, I'd just like your take on, again, I know you've briefed it at length, but the fact that there's no, to Mr. Ellman's argument, that there's simply no temporal limitation in our case law. I mean,
Okay.
and I guess it goes really to
I'll say it again.
those statements in really, I mean, what's the best description of why there is a temporal limitation?
In my world, time, the word time, equals temporal limitation. That is what the Republic investment case says. In re Caesar talks about no other county reaching the 500,000 limit for 10 years, and then in the next paragraph talks about it being improbable. It clearly includes a temporal limit. In re Marxist, the same, and I was there in the town of Gilbert case. Ms. Everett Garcia was the expert on Buckeye, and the evidence was directed at the fact that whatever was going to take place wasn't going to take place for a period of years, and there was testimony that it would take 19 years. It was put in by the defendants in that case. Those cases absolutely stand for the proposition that there is a temporal limitation and it must be reasonable.
Counselor, my problem with this case is I like the other judges, I am troubled. If there is no temporal limitation whatsoever, then legislature can take advantage of that, and there is no elasticity requirement at that point. But my problem with your position is part of our job as an appellate court is to give guidance, and the only guidance I can see that can come out of this case, if we hold your way, is that we don't know what the temporal line may be, but the line here is too far, and that doesn't seem to give much guidance.
Well, I think it does, Your Honor. Perfectly appropriate to say where the existing case law talks in terms of 10, 15, and 19 years, to point that out, and to say this case is so far beyond those cases, beyond the realm of reason, at 90 years from the date of enactment, that if you're inclined to say, we can't tell you exactly where that line is, but 90 years is so far over the line that you don't need to have a NFL replay to determine whether it's inbounds or out of bounds.
Do you think that 10 years is too far, or 19?
Well, 10 years, the court held that 10 years was too far in Ray Marxist and Cesar. To state the obvious, this is so far, 10 times that, 9 times that. 90 years versus 10 years, 9 times that.
So your argument is one of judicial restraint. We can decide it on this case, on the facts of this case. We don't need to set forth any black letter law or number of factors. We can simply, that can wait for another case where perhaps it's closer and the court can carefully examine what the evidence is, carefully examine what the factors are. But in this case, being at least 85 years, maybe 500 years, maybe never, that's just too long.
That's what courts do all the time. When the Supreme Court of the United States recently, maybe starting with Bush versus Gore, the facts, this case only applies to the facts of this case, and recently they did it, and it's done all the time. Sure. That's what courts do.
I just wanted to make sure I understood that's what you were advocating. Okay.
Thank you, Your Honors.
Thank you. Counsel, we thank you both for your excellent arguments this morning. The court will take this matter under advisement. And the court is obviously aware of the time constraints and the fact this is an accelerated appeal. But the court, we will issue a decision as soon as possible.
I would just say that I think our briefs point out that the ballots are being printed sometime in early September.
Okay. Thank you, counsel. Thank you.
front lights are.